The judiciary is a system of courts which interpret and apply the law. The role of the courts is to decide cases by determining the relevant facts and the relevant law, and applying the relevant facts to the relevant law. The Indian judiciary administers a common law system in which customs, securities and legislation all codify the law of the land. It has, in fact, inherited the legacy of the legal system established by the then colonial powers in the princely states since the mid-19th century, and has partly retained the characteristics of practices from the ancient and medieval times. The Indian judicial system is totally managed and administrated by officers of judicial service. Unlike in the past when civil service officers also were part of judicial system. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. The judges of subordinate judiciary is appointed by the governor on recommendation of the High Court. Judges of the High Court and Supreme Court are appointed by the President of India on the recommendation of a collegium. The judicial system of India is classified into 3 levels with subsidiary parts. The Supreme Court of India, also known as the Apex Court, is the top court and the last appellate court in India, and the Chief Justice of India is its top authority. High courts are the top judicial bodies in the states controlled and managed by Chief Justices of states. Below the High Court are district courts, also known as subordinate courts, controlled and managed by the district and sessions judges. The subordinate court system is further classified into 2. The civil court, of which a sub-judge is the head, followed by the municipal court at the lower level, and the criminal court headed by Chief Judicial Metropolitan Magistrate at top and followed by ACJM, ACMM and JM, at the lower level. The other courts are the executive and revenue courts, which are managed and controlled by state government through the district magistrate and commissioner, respectively. Although the executive courts are not the part of judiciary, but various provisions and judgments empower the high courts and the session judges to inspect or direct the working of executive courts. The Ministry of Law and Justice at the union level is responsible for raising issues before Parliament for the proper functioning of the judiciary. The Ministry of Law and Justice has complete jurisdiction to deal with the issues of any courts of India, from SC to subordinate and executive courts. It also deals with the appointment of judges of the High Courts and the Supreme Court. At the state level, the law departments of the states deal with the issues of the High Court and the subordinate courts. The Constitution provides for the single unified judiciary in India. The relation between judiciary and constitution is that constitution empower judiciary to act as the guardian of the law. Therefore, in common language can say judiciary is itself a constitution, but this does not mean that the court have unlimited power, because in India the doctrine of constitutionalism is also applied. However, there are a number of provisions which specifically deals with the Indian judiciary role, power and function and appointment of officer. Under the Constitution of India, the major provisions are the judiciary interprets as the final arbiter. The inner conflict of constitutionalism, judicial review and the basic structure. Book India's Skiving Constitution. Constitution, to be its watchdog, by calling for scrutiny any act of the legislature or the executive, who otherwise are free to enact or implement these, from overstepping bounds set for them by the Constitution. It acts like a guardian in protecting the fundamental rights of the people, as enshrined in the Constitution, from infringement by any organ of the state. It also balances the conflicting exercise of power between the center and a state or among states, as assigned to them by the Constitution. While pronouncing decisions under its constitutional mandate, it is expected to remain unaffected by pulls and pressures exerted by other branches of the state, citizens or interest groups, and crucially, independence of the judiciary has been held to be a basic feature of the Constitution, and which, being inalienable, has come to mean that which cannot be taken away from it by any act or amendment by the legislature or the executive. This independence shows up in the following manner. No minister, or even the executive collectively, can suggest any names for appointment as judges, to the President, who ultimately decides on appointing them from a list of names recommended only by the Collegium of the Judiciary. Nor can judges of the Supreme Court or a High Court be removed from office once appointed, unless an overwhelming two-thirds of members of any of the houses of